My name's Sam Wright and I'm one of the solicitors here in Manchester in the Inquest advisory team. Thank you, first of all, for joining us on this webinar to discuss patient safety, incident investigations and the coronial process. So let's get started then. So in this session, we will discuss what an inquest is, why an inquest is conducted, pre-inquest evidence and the patient safety incident investigation, how the patient safety investigation may assist a coroner, how the patient safety investigation may assist the legal team, your in-house legal team and any instructed panel firm. And then we'll also go through some common issues to do with the patient safety investigation and the coronial process that I've come across personally in my experience and how we might avoid these. Okay, so moving on then, quite basic to start off with. Some of you, this will be bread and butter knowledge, some it might not be, it might be a refresher. So what is an inquest then? An inquest is an investigation into a death which appears to be unknown, violent or a result of unnatural causes. Any registered medical practitioner have a duty to notify the coroner for the relevant area if one or more circumstances set out in Regulation 3.1 applies, and Regulation 3.1 is just there. The duty of a coroner to investigate a senior coroner who is made aware that a body of a deceased person is within that coroner's area must, as soon as practicable, conduct an investigation into that person's death if subsection 2 applies. And in subsection 2 it goes through those circumstances whereby it might be that someone's died of violent or unnatural death. It might be that the cause of death is unknown, and it also might be that that person died while in the custody or otherwise in state detention. And what we mean by that is it may be someone that's died whilst in prison, or someone that may have died who is subject to the Mental Health Act and detained as a result in hospital under the Mental Health Act. Okay, so the coroner is required to answer 4 statutory questions, and that is who died, when did they die, where did they die, and how they died. And this makes up what we call the scope of the inquest. So where we refer to where you hear or what's within the scope of the inquest, it's really what forms the answers to those 4 questions. Okay. So moving on, as part of the inquest process, coronial investigation, the coroner will request a number of documents, statements and or reports from those organisations or persons who may be in a position to assist with his or her investigation. Now, these documents may involve witness statements from clinicians, it may involve medical records, it may involve investigation reports such as the patient safety incident investigation. Now, I know we're talking specifically about patient safety incident investigations, and some trusts may refer to their individual investigations as something different. So it's any investigation. It might be a mortality review, it might be a serious judgmental review, it might be called something different, but any form of report that's investigating and considering the care and treatment that that person has received. So Schedule 5 of the Criminal Justice Act gives the coroner the power to request the disclosure of any documents or any other thing relevant to the investigation. Now, the reason why I feel it important at this point to highlight that at this stage, certainly for the benefit of this webinar, is quite often what I will hear is, well, the patient safety investigation is a trust document. It's for the benefit of the trust. It's for the learning and the continued learning of the trust. And that's why we're doing it. We're not doing it to inform the coronial process. We're doing it to inform trust processes and any learning. And that is all absolutely accepted and quite right too, and is understood. Now, whilst that is the case, because the coroner can request any document or any other thing relevant to its investigation, it might be that the coroner feels that any trust investigation could be relevant to the investigation. Now, what's really important to highlight at this point is that it's the coroner who makes that decision as to whether that investigation report is relevant to his or her investigation. Unfortunately, that's not a decision that the trust are to make themselves. If disclosure is requested, the trust needs to comply, and it'll be for the coroner to make a decision as to whether it helps him or her during the investigation or not. If it doesn't, the coroner simply won't admit it into evidence. He won't want anyone to speak to it. He'll decide, well, actually, it's not relevant, I don't need it. But if it's requested, it really does need to be disclosed. Therefore, if there is an ongoing or completed trust investigation into the care and treatment of the deceased, the coroner has the right to disclosure of this. So that really just repeats what I've just gone through there. Okay, moving on, and this really forms the basis of what we're really here to discuss as part of this webinar. So there's some common issues around the patient safety investigation, whether it's a mortality review. Well, let's call it an investigation into the care and treatment, or a review of the care and treatment, because that really just then covers all of the different documents that we tend to see between each individual trusts. Now, one of the huge issues that we tend to come across are delays with those investigations. There's also some issues around multiple versions of the same investigation. Now, where I feel that this comes about is quite naturally, whilst you're putting together your investigation, whilst you're going through the motions in terms of trying to narrow down the issues with any care and treatment, it may be that you have a working document, so you'll have your first draft, and then it'll go to somebody else and they will put their input in, and it might be that you then have draft 2, and then you have draft 3, and that's all perfectly reasonable. Whatever works for you and your trust in terms of getting to that final version. Nobody is suggesting at this point that you shouldn't do that. Where we have to be very careful is that those drafts aren't disclosed to the coroner. We're only disclosing the final investigation to the coroner, because sometimes what can happen is we have a working draft that's thought to be the final draft, but it's not quite the final draft, but then that's disclosed, and then we do have a final draft which changes the viewpoint slightly, and then it causes all kind of confusion. And what it can also do is create some uncertainty for the coroner and of course the family around the investigation process, and we want to avoid that ultimately, because we want the coroner to have confidence in our trust investigation. More so, we want the family to have confidence that that investigation has been conducted, thoroughly and correctly. Okay, so number 3, quite a simple one, but again, something that does come up and we need to be mindful of are grammatical errors and incorrect or misspelt name for the deceased. So just have a process in place where we have a proofreading process, check it and check it again, get your legal team to check it, ask them, actively say, we've checked it, can you double check it? Generally, you'll find they will in any event before it's disclosed to the coroner, but there's nothing wrong with asking that to happen. And it's, the more people that can check the grammatical errors or any misspelled names, the better. What we want to avoid certainly is misspelling the deceased name. Again, it's not helpful, and these errors do occur, and obviously it's not because nobody's trying to get the right content out there. It just happens, and that's fine. But let's check, let's proofread, because a misspelled deceased name, again, it's almost a little bit insensitive, and as you can imagine, it doesn't look good from a family perspective, and of course the coroner's perspective. And then number 4, another common issue is lack of communication and updates provided to the coroner. Now, what I tend to mean by that is lack of communication. It's always best if there are going to be a delay with an investigation, or you're not quite running to the timeframes that you first anticipated, and that happens. That's reasonable. That can happen. just let your legal services team know, make them aware, check in with them, say, well, this is where we're up to. We had anticipated that, you know, it would be finished by this date, but we've come across these stumbling blocks. There's further input that we need from a different division, if you like, because let's face it, when we're looking into the care and treatment of somebody, it might be that, you know, there's a number of specialities that need to feed into the one report. Now that takes time, and that is appreciated, and where possible we do, as legal representatives, try and get that across to the coroner. However, what's best to do in those circumstances is make sure the coroner is updated and they're fully abreast of what the issues are, and feed that back to your legal team, and if you're outsourced, if it's an outsourced case, the legal team to feed that back to the panel solicitor acting for you, just so we can keep that communication, the line of communication going. And that tends to go down very well. Coroners just need to know where they are to be able to further plan for the inquest itself. So there's a reason why we've gone into that in a little bit more detail. Now, we're going back to Schedule 5 of the Coroners and Justice Act because I just wanted to highlight to you a paragraph within there, which can have some quite serious ramifications in the most serious of cases. And it comes back to the delay issue that we've talked about just previously on that slide. Now, I'll read it out. The intentional suppression or concealment of a document believed to be relevant or its alteration or destruction can result in criminal sanctions, including a fine of up to £1,000 or up to 51 weeks in prison. Now, that is, you know, quite a serious schedule within the Coroners and Justice Act, and it, you know, it can have quite serious implications and ramifications for a trust. That said, what we're not saying is if your trust investigation is taking a little bit longer than expected, that suddenly your trust is going to then be issued with £1,000 fine and someone's going to be sent to prison for 51 weeks. It's going to be in the most serious of cases. So if we have a situation where a trust investigation it's delayed and there's no real justification as to why those delays are occurring, we need to be very careful in being able to kind of hope to provide justification, because if we can't, a coroner does have it within their gift, when all's said and done, if those delays are extreme, you're looking at the tipping balance in terms of when is it a delay or is it the intentional suppression or concealment. And there's going to be a line there. What I don't want to do is for you to take away from that, oh gosh, if we're running a little bit late with our investigation, we've got these really serious, we've got a fine, or we can think about someone's going to go to prison for 51 months. I don't want you to take this away from that. What I want you to be is just aware that what we need to be able to do is if there are delays, we need to be able to justify them and say why they are. And it really comes back to communication. Let's get back to the coroner. Let's check in with the legal team. Let's tell them about the struggles and the issues that we're coming across, and just keep them informed. And in turn, the legal team can inform the coroner and say, well, I'm sorry, this is taking longer than expected, and this is why. What I've seen in the past is a coroner ask, in those circumstances where the delays have been quite lengthy, the coroner has asked for a chronology of the life of the investigation and the communication that's taken place in relation to that. So with that in mind, that's also something that can be requested from you and your trust if there are particular issues with providing an investigation on time, or if there's some delays that the coroner feels are unnecessary. It might be that the coroner says, right, I want a chronology of the life of the investigation and what's actually been happening, and at which point you need to provide a chronology of who it's gone to, who's fed into it, how long they've had it, and how much time they're working to. Annual leave can also be a factor, and of course what's also really important to highlight as well, and again, I want you to know that it is understood, some of the clinicians feeding into these investigations, they are you know, on working 12-hour shifts. So they're trying to get to this investigation, feeding into it in and around their working pattern as well. And I know that can be quite challenging. But if that is an issue that you're finding, or is that an issue that is a stumbling block for this particular investigation, say so. Let your legal services team know what the issue is. They can update the coroner. And again, you're keeping that line of communication going. Now, moving on past Schedule 5 and the most serious of ramifications, if you like, in the most serious of cases where there are delays, we also have Regulation 28, which is otherwise known as Prevention of Future Death Reports. Now, you may or may not have come across these where they're more generally issued where the coroner feels there's a continuing risk of future deaths, and that's where the trust is unable to show that learning has taken place, in particular to a particular learning point or a lapse of care that the coroner has identified within a particular case. If the coroner feels there's continuing risk of death, they'll issue a Regulation 28 report and say, well, actually, I feel like this risk continues. The learning and actions are not being put into place, and the trust needs to take action. And then with that, the trust will need to respond to the coroner within 56 days, highlighting what exactly it is the trust and what steps the trust have taken to ensure that that learning and those actions are in place. Now, where that feeds into the patient safety incident investigation is in circumstances where we come back again to any delays or unnecessary delays, because what the coroner will consider in relation to that is, well, actually, if someone has died and there's an investigation into the care and treatment, and of course the care and that investigation is ongoing and it's taken quite a while, it's only when you get to the end of that investigation are you satisfied at that point what learning and actions need to be taken place and need to be put in place in order to prevent future deaths. If the coroner suspects or finds that those actions are not in place or they haven't been identified yet because that investigation hasn't been concluded, then that's where your risk of prevention of future deaths report come in and around the investigation process itself. So that's also something to be very mindful of. And we can discuss that further on one of the next slides, because I have some examples for you. Another implication could be critical comments in court resulting in negative publicity. You may be aware that a coroner's inquest is a public hearing, and therefore anyone can go in and attend and observe. Quite often we'll have members of the press sitting in the back of court, making a note, looking for the next story. If we have a coroner then criticising a trust for any delays in the investigation process itself, you can bet your bottom dollar that will then be in the next newspaper, your local newspaper, as a headline. And again, we want to avoid that, because ultimately, you know, it's negative publicity for your trust that you just want to avoid. Another common one that some of our local coroners like to do is request that the chief executive, or it's certainly threaten that the chief executive of your trust will be called to court to explain to the coroner what the delay is and why the investigation is taking so long. Now, what I don't want everyone to take away from this is, gosh, we just mustn't be so long with these investigations. They take time. They will naturally take time, and that is okay. But you just need to make sure that they're progressing. There will be hurdles along the way. You need to make sure that they're progressing and that any hurdles are resolved, and that you're noting down what the issues are. You're just making a note of what the issues are, just in case you need to justify why something might be taking a little longer than expected. And then, of course, we have increased emotions from family. It mustn't be forgotten that, of course, the investigation is for the benefit of the family as well as the trust in terms of finding those answers into what may or may not have happened in terms of the care and treatment and any lapses in care that may have been identified. Now, if we've promised the family that the investigation will be concluded by X date, and of course it's taken a little longer than expected, that may then create increased emotions for the family, which then may result in further increased emotions at the inquest itself, which will heighten things not only for the family, but of course trust witnesses that are there to give evidence. So another thing to be mindful of in that respect. Now, I talked earlier about Regulation 28 and Prevention of Future Deaths Report, and where that may become an issue around the PSII process. Now, I'm not going to read these two examples out for you. I will just give you some time to just have a quick read through the coroner's considerations in both of those cases. And that really just highlights what we've discussed on the previous slide, is that if the coroner becomes concerned that there are continuing delays with an investigation, that in itself may result in a concern of risk of continuing risk of future deaths, because of course the learning and the actions may not be in place at that time or until the investigation is concluded. And really that's just to highlight that it does happen, not all the time. It really does come down to what coroner you're working with. Some coroners can be more willing to go down this route than others, but again, just something to be mindful of. We're going to have a little talk about around how we can avoid those common issues now at this stage. Now, one of the classic examples, and every trust will have a process in place. You'll all have patient safety teams. You'll all have someone taking the lead on a particular investigation. You'll all have a process in terms of who feeds into that investigation when the terms of references are set. So this is not by any means suggesting that trusts don't have clear processes in place, because I do full well know that they do, and they have good processes in place, and it's really just the little details that sometimes create the bigger issues. So have a clear process in place, which you will have. It may just be a case of tightening that process. Now, we know with the introduction of PSII, you know, that very much sets out what's expected of trusts in terms of investigations, and it gives a lot of autonomy really to trusts in terms of how they wish or how they feel it appropriate to incidents and their incident profiles as well, and what will be appropriate for their trust in terms of the investigation process itself, and really focusing on the learning and the outcomes. How can we avoid this from happening again? Have timeframes allocated to each stage. So depending on what your stages are, give yourself set timeframes, stick to those timeframes. Where those timeframes expire, have someone with oversight of those timeframes, checking in with the next person or the relevant person to say, where are we up to with this? Why haven't we moved on? Make a note of why things may have taken a little bit longer than expected, and offer support if you need to those involved to see if you can help move things on a little bit quicker. This seems like such a simple one, but diarise, use Outlook to say, right, okay, you may be the lead investigator. It might be that you've asked a number of questions of the clinician looking after the patient on AMU in terms of their involvement. Diarise for when you might get a response, or diarise for 7 days if you like, depending on what your timeframes look like. But don't assume, right, well, this is with them now, I'm just going to wait for them to come back to me. Own it, be accountable for that task. If you haven't heard from that particular clinician on their view, or if they're feeding into the report and they haven't quite yet responded because they've not got around to it, check back in with them. How are you getting on with this? Is there anything I can do to help? Is there anybody else that we can help support you with it? Is there anybody else we need to be speaking to? All of those things. If you've asked certain questions of a particular clinician, go back to them, ask them how they're getting on. So be accountable for it and diarise it and communicate. We're coming on to number 5 there, and really that comes again to communication. Keep talking with those involved, keep feeding back to your legal services team. If you're in the legal services team, you know, feedback to the coroner. We are looking at this. This is taking longer than expected because of X, Y, and Z. Please bear with us, but this is but just to reassure you, it is progressing, and that's far better than the coroner having 3, 4, 5 months of silence on the issue. We've told the coroner that an investigation is taking place, but 5 months have gone by and we haven't checked in with the coroner and said, well, actually, things are taking a bit longer, or it might be certain stumbling blocks you've come across. It might be that another trust altogether needs to feed into the investigation itself. Now, when we're talking about outsourcing, looking for comments from other trusts or other organisations, it might be a safeguarding team that needs to feed in. Let the coroner know, because the coroner won't automatically know the size of the investigation itself and the work that's going into it. And I'm not sure that it by all coroners, it is fully appreciated how long these things take. So just keep communicating, communicate with your legal services team, and legal services communicate with the coroner and any panel firm that's instructed, if you do have a panel firm instructed. And factoring time for proofreading. So we know that some investigations need sign off by senior leader teams. That's your process. No one can tell you that that's the wrong thing to do. Quite reasonable and accepted that needs to happen. But in that time, just factor in the time for proofreading from senior leader teams as well, just to go over to make sure there's none of those grammatical errors that we've talked about previously. And then manage expectations from the outset. Now, it might be at the outset, we think an incident investigation may take 3 months, but we need to err on the side of caution in telling the coroner that it's going to take 3 months, because ultimately it may take longer. So unless you know it's going to take 3 months and you absolutely know it's going to be finished by that date, there's nothing stopping you from saying, well, actually, an investigation is ongoing. At this point, we don't have a deadline, a time frame, but we're working towards this date, and we'll keep you updated if that changes. So we're working towards X date, but we're going to keep you updated if that changes, and do keep them updated. Because again, what that does is it builds a rapport with your coroner's officer as well. The coroner's officer will send your email, forward it to the coroner and say, I've just received this from the trust in relation to the investigation. And the coroner will appreciate that you've actually taken the time to check in and say, well, this is where I'm up to, because it helps him or her plan in terms of any listing day or any further evidence that they might need. So what are the benefits of moving things forward in good time and without unnecessary delays? Well, the trust becomes better informed of any risk prior to inquest. When we talk about risk, we're talking about any risk of prevention of future death reports. We're talking about risk of any potential neglect riders. And as soon as we know what the investigation says in terms of the care and treatment, certainly as legal representatives, we're in a better position then to advise the trust on risk and update the senior leader team as well in terms of, where that risk lies and what needs to happen next in terms of mitigating those risks. It gives you an opportunity to instruct legal representation from the outset if you want to, if you need to, because we all know that, some legal teams are very well set up in terms of their own structure to be able to deal with inquests themselves. If admissions are required, admissions in terms of breach, if we've got a lapse in care that may have caused or contributed more than 50% on the balance of probabilities to the death itself, then we might need to advise on whether admissions need to be made. Pre-admissions prior to inquest can be helpful in the sense that it may limit the witness list. It may mean that we don't need to call upon so many clinicians to attend inquest. It also means that if there's any future clinical negligence claim, any costs of solicitors acting for any potential claimant are reduced in that respect as well. So there's some benefits in getting to the bottom of any issues in terms of lapses in care. Time to consider and prepare assurances around learning outcomes to avoid PFDs and any other adverse outcomes. So the sooner we get to the bottom of the incident itself and whether there's any learning, the sooner we can put learning into place and again mitigate the risk of any prevention of future death report. We're better informed to be able to provide full support to witnesses in advance of the inquest. So they're fully briefed in advance of the inquest as well in terms of what to expect, what's going to be considered as part of the inquest. If we've got legal representatives acting for family, that can make things a little bit more complex as far as the inquest is concerned. It can make questioning a little bit more difficult in certain circumstances. So it's all about being able to prepare our trust witnesses as well in terms of what they may expect at inquest. And then it limits the risk of any new issues coming to light that have not been considered. Sometimes, and this is common, sometimes it might be that we have an inquest where issues do come to light as a result of witness statements that are received from clinicians, but there hasn't been any formal incident investigation as such, because this is the first time that the trust are actually aware of potential issues. And had there been an investigation, it might be that those issues wouldn't be coming up at the last minute. We wouldn't be on the back foot. It doesn't happen often, but it can happen. Okay, we touched briefly on patient safety incident response framework. I just wanted to mention this briefly just because it makes sense to do so as we're talking about PSII. And of course, this has been probably your life for the last two years, certainly. So just some common themes there in terms of what PSII brings out. What the framework establishes, and it establishes the NHS approach to the development and maintenance of effective systems and processes responding to patient safety incidents. It's a contractual requirement and it's mandatory for all providers of NHS funded care. There's no longer a differentiation between patient safety incidents and serious incidents. So you will know probably a lot more than I do about this, but ultimately what it does is it gives trusts more autonomy to make a decision themselves in terms of how they will investigate incidents. And it might be that a formal investigation isn't warranted in certain incidents. It might be that you switch straight to the learning. You may have a meeting, you may have a presentation for staff involved. And it really is more focused on learning rather than anything else. But hopefully it reduces the time-consuming nature of the old system in a way, but I'll be guided by you on that, on whether it does or not. Okay, just in terms of PSII itself, in terms of all of the things that we've talked about, doesn't really change any of the expectations that the coroner will have in terms of what they can ask for. It might be that there is no investigation around the death itself, but there is some learning. It might be that you've chosen not to conduct a formal investigation for whatever reason in terms of your own PSII plan, but there is learning, and learning has been identified. Now, in those circumstances, that what the coroner may request is a witness statement from those involved in terms of the learning, or to speak to the learning itself, or what the issues were, what issues were identified, and what the learning is. So where we don't have a formal investigation document, it might be a separate witness statement from one of those involved to speak to that is necessary, but it's going to be very much on a case-by-case basis, that in terms of what's required and what's needed. It might be a formal meeting has taken place, but no formal investigation document has been collated. It might have been a meeting, say for instance, some trusts call it a round table meeting, where they've discussed the care and treatment. They've identified that there were issues and they've had a chat about how those issues may be mitigated in the future. Now, following that meeting, it might be that there's been some notes taken as a result, and it might be that the coroner asks for a witness statement based on those notes, just to highlight what the trust is saying that they're going to do and put in place moving forward, because the risk of a prevention of future death report still exists despite the shift in how incidents will be investigated moving forward. Similarly, there's even less likely that investigations, whatever form they take, will deal with causation. Now, causation is always a consideration for the coroner in terms of whether any lapse in care caused or contributed on the balance of probabilities to that person's death. Now, how the coroner will seek to get around that, if it's something that he wants a clinician to speak to, is a formal witness statement providing a view on causation. If that witness statement is requested, the appropriate clinician needs to be approached to provide that witness statement. Now, it might be that that clinician can't give a view on the balance of probabilities whether the lapse in care caused or contributed to the death, and that's a reasonable response. If that clinician can't give a view because there's so many different variables all interplaying in terms of the death itself, there might be a number of probabilities all acting against a particular person and their reserves. So what you can't say is whether that was the final tipping point or whether it was, you know, the lapse in care itself. And if that is the position and that's that clinician's opinion, that clinician simply needs to set that out. And you know, it's as simple as that. If you can't say, you can't say. You just have to say why you can't say. I felt it important to mention that because quite often we have clinicians get a little bit anxious really about being asked about causation, and it's almost as if they feel they're putting on the spot to say one way or the other. If you can't say, you can't say. But you do need to put that down in writing as a witness statement to assist. It's then for the coroner really to go out and make a decision as to whether an independent expert opinion, someone independent from the trust, is then needed to assist him or her further. Okay, that brings us to the end of our slides. So we'll invite questions now at this stage. Thank you very much.
Thank you, Sam. Somebody asked early on, does Schedule 5 apply to the provision of witness statements as well?
Yes, absolutely. So any document that the trust feels may assist in the investigation, so certainly witness statements comes under that remit, yes.
Thank you.
Just to add to that, some coroners will say, right, you've got 28 days to get this witness statement to me. Again, the same applies with witness statements that we've already talked about around the PSII. Quite commonly we see, well, actually 28 days for a witness statement to be provided, medical records to be obtained, witness statement provided and sent over to the coroner, finalised and what have you. It takes longer than that. Just keep the coroner updated. That's what I would say.
Delays are becoming more so recently with NHS reorganisations and key staff and managers moving on and therefore hard to track down. Is this taken into account with Schedule 5?
Yeah, I guess it comes back to communication again. Quite often we find that staff will move on to other trusts, and as far as possible, if the trust that's been requested of the witness statement can make contact with that clinician or make attempts to make contact with that clinician to request the witness statement, do so. Let the coroner know that you're doing that and you're taking those steps. If then at that point you you know, come up a bit of a stumbling block because they have moved on and they're working for a different trust. At that point, if you've done everything that you can, what I wouldn't do is continue to chase and use all of your valuable time to do that. Then what I would be asking the coroner to do, a coroner's officer, is make contact with their new trust, if you know where that is, to obtain the statement directly.
How does this fit in with the PSIRF model, as this gives a much longer time frame for the completion of investigations and reports?
Yeah, you're quite right in relation to that, because I think under the old model there was a 60-day time frame, but with PSIV it's very much left to the trust to speak with families, to speak with trust staff, and come up with a consensus as to how long this particular investigation will take, and that's fine. What I would say is just let the coroner know what deadlines you're working to, when you expect it to be ready. I guess when we get to a 6-month point, we really need to be saying we've had issues, we expected it to be ready by now, it hasn't been for X, Y, and Z, and provide reasons why it is taking longer. What you don't want to do is be in a situation where, of course, the coroner is expecting something to be provided, because, of course, it may be that he or her has been promised something by a certain date and it's not materialised. What you don't want to do is be in a position where you're going back to the coroner and saying, well, actually, sorry, I know I promised you this date, but it's not ready, and then not having a reason as to why it's not ready. So really do keep track of any stumbling blocks that you come across. So then if you do need to justify why it's taking longer than first anticipated, you can go back to the coroner and say, this is why it's taking us longer. And it might be resources, it might be annual leave, it might be sickness, it might be having to go and speak to other clinicians at different trusts. It might be there's a whole new team that needs to feed into it. You might be waiting for another report to inform your report. Whatever it might be, just make a note of all of those things, just in case you are in a position where you need to justify a further length of time as to why things are taking longer.
Statements from witnesses are often received and disclosed before the investigation has been finalised, and there may be concerns or issues raised in the investigation not identified in witness statements. How do you deal with that?
Well, ultimately, the witness statement itself is that own clinician's opinion in terms of their care and treatment, unless, of course, we've got an overview statement by a clinician having a review of the medical records. Now, I guess if there's a conflicting issue between a witness statement and the investigation report itself, then it's really a case of bottoming that out with the clinician that's already provided the statement and finding out if they actually agree with the investigation itself. If they don't agree with it, so it depends on the circumstances, really. If it's a conflict in terms of the information that's been provided, we need to go back to that clinician that's already provided that statement and see if it's necessary to provide an addendum statement further to the one that's already been submitted. It's quite usual to have a situation, of course, where witness statements are submitted prior to the investigation, because the investigation naturally takes a lot longer sometimes than the witness statements themselves. So my advice in those circumstances would be deal with it on a case-by-case basis. If the issue is a conflict in terms of the information that's being provided, depending on what that is, you need to consider whether an addendum statement is needed just to tidy it up for whatever reason, depending on what the issue is. I hope that helps. It's quite a wishy-washy answer, but it's very contextual in terms of what you would do about that, but definitely consider if an addendum statement is needed.
Also, regarding the PSIRF model, how does this fit in with the more thematic analysis for wider learning rather than individual reports?
Well, really, again, it's a case of, depending on what your model looks like and what your review looks like, whatever form that takes, if there is learning, and that learning is learning that relates to the death itself, then again we come back to, well, how do we get that across to the coroner? Because of course we're looking at a thematic review as opposed to anything else. So do we provide that evidence as part of a witness statement? Is there someone that can just provide assurances to the coroner in relation to that through a witness statement rather than a formal investigation document itself?
Are there any penalties if a trust ignores a PDF? If so, what are they?
So with a prevention of future death report, there does need to be a response within 56 days. There will be penalties if the trust does not respond, and certainly the CQC could become involved, because ultimately a recommendation is being made there in terms of action that needs to be taken. And if a response isn't provided, then the coroner could quite rightfully refer that further for non-compliance. It's certainly something that I would not recommend. If a PFD has been issued against your trust, then do, you know, make every effort to respond. If you're struggling with the time frame, 56 days in terms of getting your response over to the coroner, again, get back to the coroner and say why, and ask for more time, ask for an extension.
Has the embedding of the medical examiner role helped the coroner and changed the scope of inquests over the last few years?
Yeah, certainly. With the medical examiner role, it certainly assists the coroner in terms of the medical cause of death itself and the need for conducting post-mortem. So I expect it certainly has assisted and, of course, sped up the inquest process itself.
As witness statements are no longer recommended as part of PSII, this could cause an issue if the coroner does not ask for this early, as information may be forgotten.
Yeah, I mean, even though witness statements are not required, we'd still recommend that there's some formal note-taking process involved. So, of course, if in terms of an incident itself, for example, a decision is made to be able to deal with that incident, discuss that incident, consider whether there's any learning, then the approach for that particular trust on that occasion is to sit around with the relevant clinicians and have a discussion about the incident itself and any learning that may come out of it. That discussion itself, it's advisable that that's recorded in some sense, even if it's note-taking form, just so the trust at some point are able to prove that that has taken place. And if they need to rely on it further down the line or refer to it, they can do so. So always have, and we'd always say this in any meeting, any meeting discussing certainly learning or incidents, anything of the like, have a formal note-taking process in place.
Given PSII has moved to interviews, not statements, will the coroner start referring to interviews and not statements?
If it's moved to, it could be, because like we said, under Schedule 5, it's any document or any information that may assist. So if there is interview documents as opposed to statements, or there's an interview transcript, if you like, there's nothing stopping the coroner from requesting that.
Who constitutes the legal team in a DGH?
It really comes down to the District General Hospital themselves and what setup they have in their own internal governance team, really. It really does vary from trust to trust. It may be, for instance, in some trusts or some smaller trusts, you might have, you know, an assistant director of nursing or an assistant director of governance that may take on the role of legal services as well, because they have a much smaller remit and smaller workload from legal services point of view. So it really does depend on that individual trust in terms of who's dealing with that work.
Is there a time limit by which an inquest has to end after a death?
There's a time limit within the coroner's investigation rules 2013, and from the opening of an inquest to the conclusion of an inquest, the coroners are duty bound to have that started and finished within 6 months. Having said that, that doesn't always go to plan, because further evidence comes to light, then creating the need for further evidence. It might be medical expert evidence is required. It might be a further organisation needs to be contacted that it wasn't anticipated previously. So there can be a number of delays that you know, affect that 6-month time period. But as a general rule, 6 months is the time frame in which a coroner needs to conduct his or her investigation.
Is it right to include learning in coroner's reports, or should it be purely chronology and context?
Oh, absolutely. I mean, it's quite common to have witness statement highlighting. You might have a divisional lead doing a review of the care and treatment, and it might be that it goes through the chronology of that care and treatment. That particular witness statement identifies an issue, and then it goes on to say what that division are looking to do in the future to mitigate the risk of that issue from occurring again. It really does depend on how the trust would like to approach that, but it's quite common to have learning included as part of witness statements if it's maybe a smaller learning point than something that warrants a full investigation document.
If the coroner calls you as an expert witness, does the individual being called need any specific training to do this role?
No, so this is quite a common question that comes up time and time again. I mean, ultimately, if the coroner is asking a clinician to provide an opinion, a clinician, medical clinician usually is regarded as an expert in their field in any event, because they're a doctor and they're asking an opinion within their field. There doesn't need to be any additional training to attend and provide that opinion evidence, no.
Does any document that reviews the incident to see whether further investigation is required needs to be sent to the coroner? We do a 74-hour briefing following receipt, but this does not result in a further investigation. To date, we have never sent these. Any learning is in the witness statement. So does that make sense? So
quite common what you'll have, certainly under the old system and the old investigation process, quite commonly you'll have it. Some trusts will do what's known as, so I'll take a high impact learning assessment, for instance, which will be a mini snapshot or a mini review of the care, just identifying sections of the learning itself, but it'll be a summary, and then it might be as a result of that moves on to a bigger size investigation or a care review or a mortality review, and it might be that there's a further report that's created which is a more in-depth view of the care and treatment. Now, as a general rule, if that final document, if you've got a number of documents involved in it, you know, informing the investigation process, and then you've got to a final document that's much bigger because it needed to be much bigger because the circumstances warranted it, but you've got these smaller documents that have been created previously. If, say, for instance, the bigger document covers everything that's within the smaller document, you just need to disclose that bigger document because it's saying the same thing as those smaller ones. If there's no new information in that that final document, and then disclose the final document, and then if it comes to light that there are these other documents and the coroner says, well, why didn't you disclose that? You'd be right, you'll be reasonable to say, well, we didn't disclose it because it says the same thing as that, so it's duplication. It's only if there's something within that document that's new that may assist that then it will need to be disclosed. In circumstances whereby, say, for instance, an incident's been investigated but there's no outcome, there's no learning, there's no reason why you can't disclose it. And I'd probably say disclose it in any event if that's the only document, because it really just identifies that the trust had taken steps to review the care.
Can the trust force the author of a witness report to change the report or reduce the length?
No, I mean, ultimately, sometimes what we get is the coroner asks for an overview report, and sometimes it can be quite difficult for clinicians, certainly if they're not experienced in writing witness statements, to provide an overview, because that clinician doesn't know what's going to be completely important to the coroner. Now, with an overview report, what we'd always suggest is review the medical records and see what's relevant to the care and treatment. You don't need to be rehearsing every single entry in terms of when they had lunch and when they went, it depends what's relevant to that particular inquest. Now, ultimately, if that clinician has drafted a report, the coroner can ask that clinician to add to the report if it doesn't particularly deal with something that the coroner expected it to deal with or asked for it to be dealt with. The coroner can't ask for the report to be changed. It's their content, it's their witness statement, it's their statement of truth. It might be that the coroner says, it might be 30 pages. The coroner might say, I can't possibly get through 30 pages. Go back and have a look and see if you can reduce it to the relevant issues, or the issues of that are relevant to that particular patient, if you can. Some coroners might get a little bit grumpy if, say, for instance, a witness statement is disclosed and it's 30 pages long, and the coroner wants to reduce the length of the evidence at inquest. He can ask. It's up to that clinician. It's their witness statement, and it's their statement of truth.
Where an SI/PSI investigation has taken place and the findings clarify the initial 48-hour report concerns, would the trust oppose sharing the initial report so as to avoid confusion?
Yeah, again, if, say, for instance, the bigger report covers the matter, the content of the smaller report that was done earlier, just disclose the final report. If, say, for instance, you have a situation where we have a witness statement or a clinician that refers to a meeting about that earlier report, it might be that the coroner says, oh, hang on a minute, where is this? I haven't seen it. And they'll ask for you to disclose it at that point. And then if it's requested, do disclose it. But then, just justify why you hadn't disclosed it previously, because, of course, if it does cover the content of what that large report covers, it doesn't make sense to duplicate. But if it's requested, then certainly do disclose that earlier report.
The ethos behind PSII is of a just culture and creating a psychologically safe space for staff to explore the incident and generate an improvement plan without fear of blame. This may be compromised if the after action review or learning MDT review are disclosed in full to the coroner. Is it acceptable to submit a summary to the coroner, e.g. the action plan alone?
You can submit a summary, but don't make it a secret that something else exists, because ultimately, if the coroner requests other documents, then they are entitled to see them if he or she feels that it may assist with an investigation. If you decide to submit a summary, that's fine. But maybe highlight that there is something else there in the background, just in an attempt to be open and honest, and say why you haven't disclosed that, or why you're not providing the full report, because and what your concerns are in terms of providing that report.
Does the coroner have a responsibility to inform the witnesses that they are interested parties, especially if a witness changes from an ordinary witness to an interested party during the hearing?
Yes, certainly the coroner needs to consider who should be interested parties prior to the inquest. But that said, it might be that when we get to inquest, the coroner makes a decision at that point. It might be that new evidence comes to light, which means that he's now declaring that particular, either a clinician is an interested party or a trust itself, because it can be an individual or it can be a trust. So it really just depends. Generally, where possible, the coroner should be informing those that are interested parties that they are interested parties prior to the inquest, so they can make the necessary arrangements in terms of legal support and representation if that's something that they feel that they need. However, having said that, it's not uncommon for interested person status to be given at inquest. What I would be saying at that stage is asking for some time or an adjournment to consider the position further, because the coroner really should be giving that person then an opportunity to representation. And if you're already in the midst of an inquest, you don't have that opportunity to do that. So I would expect the coroner to take the decision to adjourn at that stage to give a reasonable opportunity to that person for representation.
Do you think more PDF statements will be requested by the coroner due to longer timescales with the PSII report?
That all comes down to the coroner themselves and how difficult they want to be. If it really comes down to as well whether they consider that there is a continuing risk of future deaths. If the coroner is or does have a concern that because of any delay, if you like, in terms of the PSII report, that there is a continuing risk of future deaths, then the coroner can issue a PFD as a result of that. So it all comes back to whether the coroner feels that there's a continuing risk of future deaths. The reason why we mention it in this webinar is because, of course, if we're saying that actually the trust is not putting into place any actions or learning until that investigation, whatever form that takes, has concluded, then during that period, that risk continues, if you like. Now, there are some trusts that will, there is a process in place that if you've got a serious incident, there's immediate actions that need to be put into place to protect patients, which need to be put in place imminently in that day. If that happens, and you can provide any assurance to the coroner, well, yes, whilst this investigation document is taking some time, we can assure you that we have identified certain aspects of learning which are in place now that will mitigate the risk of that prevention of future death report. But it really is situational dependent and whether that is actually possible, because of course, until you've got to the bottom of your investigation, in most circumstances, I expect, and I don't conduct these myself, so I'm guided by you, that I expect until you get to the end, you don't really have a full idea as to what that learning is or what those actions need to be, if I have understood the process correctly myself.
Can the bereaved family request an inquest not to happen? Could that mean that certain safety issues are then not investigated?
In terms of whether an inquest is conducted is not the family's decision or not. In terms of whether they take part or take part in the inquest, that's a matter for them. It might be that they decide that they don't want to participate, and of course that's entirely their choice. But in terms of whether an inquest is conducted or not, that's very much a coroner decision, a coronial decision based on the legislation. Thank you very much, everybody.